Hi, this is Curt and welcome to another edition of Fire Law Roundup.
You want to do? Why don't you do your last one, and then we'll go to the biggie.
Yeah. Okay. Well, this next case is out of Seattle, and it's another settlement, but it's a difficult case. It's one that I've seen in my experience in the fire service. Okay, when I first came to get into the fire service in 1972, there was absolutely no reason why we would not respond into a scene, no matter what was going on. And then I'd say when I got on Providence in 79, that's pretty much how we operated. We would never stage, we call it staging, but we would never hold back waiting for the police. And as things started to get more violent in cities, not that they weren't violent, but when I first came on, there was a lot of people getting hit with baseball bats and stabbings. We didn't have a lot of shootings.
And we weren't the targets. Normally,
But in society, there just weren't that many shootings. There really weren't. And then I'd say in the mid 80s with, the war on drugs, and it just seems like drugs exploded in the 80s. And by the late 80s, early 90s, we were having discussions, and I was working on policies and procedures back then, that we needed to come up with some way that we weren't going to find ourselves in a situation that we weren't going to be able to get ourselves out of. And so we started, and not just Providence, but certainly other fire departments were looking at the need to hold back. And I would say by the 90s, most fire departments had requirements that you're not going to go into a known or reported dangerous situation. And I'm not danger could be a fire on the highway, but I mean a violent or threatened violence at a scene without police support or police securing the scene in advance. So what happened here was Seattle apparently created a list of addresses where previous responses had led to medics or firefighters being either threatened or subjected to violence. And they had this database, and whenever you would go to that particular address, you'd have to wait until police get on the scene and secure the scene. So that was sort of their protocol, kind of a high-tech advancement of what we used to do in the 80s and 90s, applying, a computer-aided dispatch and all the different functions that we have today. We didn't have those back then. We got them now. At least we didn't have them. Maybe Phoenix and some other cities had them, but we didn't have them. Okay. But now what happened here was there was a mix-up. Apparently, someone who used to live at this address had displayed some violence toward fire and EMS, but the current occupant had not. And as a result, while the EMS and fire were awaiting police response, there was about a 13-minute delay. The person had coded, and they were never able to resuscitate him, and he died. He was a young man, 46, and he passed away. And his family filed a $10 million wrongful death suit. And the city settled for 1.8 million. And when I lecture on liability, one of the points that I make is that when someone suffers a loss, there's a couple of things that they want to make sure. Okay, number one, they want some sort of compensation, but more important, it's really not about so much the compensation, but they want to make sure that the person who is responsible for what happened acknowledges their responsibility and has taken affirmative steps to prevent it from happening again. And that goes against what we've been taught in law school, by the way, right? We're taught to circle the wagons. Nobody says anything without the lawyers saying it's okay to say, it's all hands on deck, we're at war, okay? And that is actually counterproductive to settlements. And my son, my son's an attorney, my son's a surgeon. And they teach him the opposite. They teach him that if you make a mistake, you acknowledge it. And this, I think, is a pretty good example, although 1.8 million is a pretty big settlement. But certainly it's better than 10 million. And some of the comments, I included some of the comments of the attorney in the case about the importance of the fact that the city owned this, that they had made a mistake, that they had not, at the time, they had not been updating the addresses. and that they've made a commitment to, change the way that they were doing things and start, updating those addresses. So I think there's some important lessons there that we need to understand. But
yeah, and people, I want to really make clear so no one gets this wrong. This case was not about a protocol that said stage outside. That protocol is fine. You can highlight things as hoarder houses or dangerous areas, right? You can have staging, the active shooter stuff, stage until police. This is not a case that says you can't stage. Staging is fine, right? Not rushing is fine. But if you create a system where you say, don't go in this house without police or whatever, you better have a way to regularly update that. I will tell you, in my county, when I'm chief, only the chiefs could place notifications to stay out, and they would have a time. And you didn't get a notification that it expired, which I didn't like, but they would only last for so long, and then you've got to re-up them. So your stay away orders automatically expired, which is the right thing. So if you have a stay away order or dangerous house, and hoarder houses are big deals now, right? You don't know it's still a hoarder house. You don't know the patient died. You don't know the person's still dangerous or lives there. I think you've got to have, months or 2 months, no more than 3 months, automatic tickler systems, right? Where you go back and you check, just don't leave it on there. Now, somebody might say, well, what happens if we set it for 3 months and then the situation was corrected after 1 month, and then in the second month, we don't go back and check? I don't think there's liability there. I think if you have a reasonable system in place, not that I can cite to a case for that, but that's not negligent, right? Here, they had no system. They acknowledged they changed the system. They're improving the system, but they had no system to go back. So if you have these, this is a great wake-up call to everybody, because I'm sure we have hoarder houses and things like that where we said, don't go in, danger. You better make sure that marker warning is still in place, and please have a reminder system to go back and look every I don't think any more than 3 months. I think you've got to verify, and however you verify it, right? We check the records and it's still whatever. We drove by the house. And make notes. In big cities, Detroit, other places, right? You probably have a lot of these, which are marked as arson, dangers, and things like that. Keep the records where you verified that it was still a current danger. Please don't just go back. You're never at 100 houses, 50 houses. You need proof that you checked.
Yeah, the violence issue, I'm thinking about it. Back in the day when we worked on the policies and trying to work on this, we didn't say that certain addresses would be designated. It was based on the information that dispatch had. If dispatch had a shooting or a stabbing or violence at the scene, then we would stage. We wouldn't stage because you went to 123 Main Street and we had a problem in the past. So this is kind of expounding on that, which I think is good. And I think it's reasonable that we have that. But like you said, you've got to have some sort of a process then to make sure that if you're going to say, we're not going to go into 123, even if it's for a heart attack, even if it's for an elderly woman that fell, whatever it may be, something that there's no reason to suspect violence. It's just the address. You've got to have a system there to make sure that that address is properly still on that list.
Yeah, it's funny. It's not funny, but I remember when I was chief, we got a call right near my house, maybe a mile up the hill, for a heroin overdose. And, we went there and resuscitated the person, whatever happened, but it was a heroin overdose, which is a crime, but, and then 5 hours later, after responding to that call, we go back to the exact same address for a fully engulfed fire. And I responded, not thinking about it, because it was like 6 a.m. or something. And, before that, it was probably 1 a.m. So I didn't put the two together. Dispatch comes on and says, Chief, be aware, you're responding back to the same house where you were last night, and now it's on fire. And it matters having that heads up. I wasn't thinking it could have been the next shift. And, it just, those types of heads up help prevent, maybe not that West Webster was that, but help prevent those types of situations. And so I just want to be clear, Curt, and to everyone listening, Curt and I are not saying don't have this system. We are saying make sure you check that it's current, because I could see people saying, oh, you said don't do it. That's not what we're saying. We're saying keep it current, right? Then no liability. Okay.